So I have a client who came in the other day and asked the following question. They said, I've got this tenant who authorized a list of repairs that I had no knowledge about on a rent property. They went and called somebody up to do X, Y, and Z, and now they're sending me the bill for this. Am I liable for all of these charges? We're talking about unauthorized repairs. Let's get started. Well, the first thing I'm going to tell a landlord who comes to me with a situation like this is, what does your lease say? And what steps have you taken to discuss repair procedures with your tenant? Now, if you tell me, well, my lease is 100% silent on repairs, well, then you might have a problem, because it may be a reasonable assumption that the tenant did what they did. I don't know. Again, facts are going to differ from case to case, but if your lease is 100% silent on this issue, you've got a bad lease. You're going to want to go back to the drawing board and get something better. I know in the lease that I draft for landlords, I state specifically that any repair that happens on the property must be 100% authorized by the landlord. That the tenant, in fact, has no authority to authorize a single repair. And the reason that my lease says that is because we don't want to give the false presumption that when something goes wrong, the tenant is authorized to deal with it. And the reason we want to pull that authority from the tenant and keep it expressly on the landlord is because, number one, we have no idea the quality of the workmanship that the tenant is going to invite. When the landlord is 100% in charge of all repairs, they're 100% in charge of who comes in to complete those repairs. Additionally, when it comes to cost, we don't exactly know how much that tenant really paid for those repairs. I've seen instances where you get invoices and they look a little bit shady, and there's almost no way to confirm yes or no that this was actually paid by the tenant. When the landlord is 100% in charge of those invoices, you're in control of the costs that go into your rent property. And so it's important that the tenant is absolutely clear. You do not authorize that they go and ask for repairs of any kind. Now, in the state of Texas, there is a provision in the property code that allows a tenant, in an extreme set of circumstances where you, the landlord, have failed to do your duty and repair a necessary item on the premises. And what makes it necessary is that there is some material effect to the health or safety of an ordinary tenant, and that you've been given written notice and a reasonable amount of time to deal with that defect. If that defect persists after written notice, then the tenant can potentially send you written notice saying, I tell you what, I'm going to give you one more shot at this, but if you don't get this done within a reasonable amount of time, usually about 7 days, if you don't get this done then I will pay for the repair, and then I will deduct that repair from the following month's rent. There is no procedure necessarily that allows the tenant to pay for a repair and then send you the bill. If, however, this has happened, then you might find yourself in a situation where either A, that tenant's going to haul you into court and force you to pay it, or that you and the tenant have to work something out with regard to that repair. Because the truth is, if these were necessary repairs, and if your property benefited by these repairs, then there's an argument to be made that you received a benefit, and if you didn't pay for it, it would be unjust. However, typically, anything that the tenant does to the property that's unauthorized, especially when in writing you have prohibited, should get no benefit, or there should be no compensation to that tenant, again, assuming that all of these are in place. A written lease with a strong prohibition to any kind of repair or modification allowed on the premises. Now, that doesn't mean that even with this provision in place that you're going to be able to avoid litigation when a tenant acts unilaterally. Instead, what you're going to have is probably a pretty good defense. Now, that being said, again, you're going to consider the things that the tenant did to make the place better. But if in fact things didn't get better, the tenant didn't improve the property, they damaged the property. Here's a common example. The tenant pays a third party, say $1,000, to come in and paint the whole top floor. All of the bedrooms get painted, sometimes the same color, sometimes all sorts of colors. And then the tenant says, well, I improved your property, please pay me back. But generally speaking, especially if the lease already prohibited such things without prior consent, it's unlikely that this tenant is going to be able to recover this money because, again, in this situation, they probably didn't improve the property. For you to get it back to the state that the property was before, it's likely going to cost you money. So, in fact, they have harmed the property. Let's say, though, that the issue had nothing to do with paint, but instead had to do with your air conditioner. And the air conditioner goes out in the middle of the summer. It's July, and we're in Texas, and the tenant takes it upon themselves to completely repair or replace your AC unit. And so you have to ask yourself, was that repair absolutely necessary? If it was, and you benefited from that repair, then you're likely going to have to discuss some kind of compensation because of the issue of unjust enrichment. But if instead the tenant made some repair that was not necessary or went above and beyond what was actually required, now you have a dispute to resolve. As always, I greatly appreciate your support of this YouTube channel. Give us a like if you are enjoying what you see. And if you have a question or comment, leave that below. I'm happy to answer those questions myself. So what do you do to address the dispute between yourself and your tenant when the tenant has authorized some kind of repair or some kind of work on your property without your permission? Again, you set in place a prohibition in your lease, and you can prove that the tenant never received written consent from you to get any of this work done. This dispute might be resolved in a couple of ways. You may, for example, simply deduct your damages from a security deposit amount, and your tenant finds that acceptable. However, it may be that the tenant completely disagrees with the deductions from the security deposit and disputes the fact that you were benefited from this repair, and decides that they're going to sue you because they feel they are entitled to some kind of compensation and not that they in any way caused you damage. You need to be prepared to present either a good defense or your own affirmative claim in a lawsuit against your tenant when you are seeking to establish what was authorized and what just wasn't. Make sure that you are able to establish for the court the baseline that is set before your tenant has ever taken possession of the property. You have video, you have photographs, you have evidence of the property's condition before the tenant ever took possession. Additionally, you have receipts either of estimates that you've received or actual costs that you incurred to rehabilitate the property after the tenant vacated. This way you're able to establish for the court not only the harm that you experienced, but also what you did to remedy the problem. Finally, you want to be able to demonstrate to the court the express limits in your lease that would have otherwise prevented a tenant who was not violating their lease from incurring such costs or causing such damage to your property. By having this evidence in place, you are likelier to be successful in the event that a tenant sues you or that you have to go after them for the amount of damage that they have caused to your property. When dealing with issues like this, the best bet is to handle all of it while the tenant is still in possession, while they're still connected to you with that lease. The lease will turn out to be your most powerful ally in a situation like this. Think about it. If the tenant causes a lease violation by paying for some repair or some modification to the premises that you didn't authorize, your best bet is to come in, to give them written notice of this violation, and to let them know that you will pay to have the unit restored, but that they will be the ones actually covering the costs. Once you complete the repair and rehabilitation of the property back to its original condition, let your tenant know that you are issuing them a bill and that you expect to recover during the tenancy full payment for the cost that you incurred for them authorizing without permission some repair or modifying the premises without your permission. By insisting that they cover the costs while they are still in possession, you have the highest degree of leverage of actually receiving the compensation that you're entitled to based on their actions. Naturally, if they don't pay, they don't stay. In fact, if you issue a bill and give a reasonable amount of time for the tenant to pay for the damages they caused and that you have repaired, they've received that bill, have had an adequate amount of time to pay it, but have not done it, but they do make a payment for a subsequent month's rent. If you have an application of funds clause in your lease, you can take those sums and apply them to the non-rent items on your ledger first. In this case, it would be the cost for repairs. If you apply that payment toward the cost of repairs first and some amount is left over to be applied to the rent balance, you can issue a second notice to your tenant of non-payment of rent. Now they will argue with you and say, no, I paid the rent, you misapplied those funds. To which you'll respond by pointing to the lease that talks about the application of funds. You'll point to the bill that clearly establishes that you were damaged by their unauthorized work. And then you can expect one of a few options by the tenant. Either A, they will sue you and you'll have to resolve the matter in court. Or B, you'll have to sue them for eviction because they refuse to pay any amounts in addition to the repair costs. But your worst option is to simply let it slide, because you will ultimately eat these costs. And it may be that the tenant further damages with additional work or additional unauthorized repairs that they call for, again, without your consent, and that do not in any way improve your property. These are not things that you should tolerate. You should definitely meet any instance of unauthorized repair or unauthorized modification of your property with written notice. You should always repair those things while the tenant is still in possession, and you should always issue a bill to the tenant to make sure that you recover these costs from the tenant while they are still in possession. This way, if for whatever reason you receive sums, you can apply them to those bills and then issue a notice of non-payment of the rent in accordance with the application of funds clause in your lease. If you have a situation where your tenant has authorized certain repairs or has modified the premises in some way that has caused you damage, you may need to reach out to an attorney to discuss the facts of your case to see how you should proceed to get recovery of your losses before the tenant has left. Naturally, if a tenant has left and you still have a viable claim, you can sue them, but I'm telling you, it's so much easier to do if they are still in possession. You have much more leverage, and the likelihood of recovery is much higher if the tenant is still in possession of the property. If you find yourself in a situation like that, you should contact an attorney. Make sure that you've evaluated your facts for the best possible recourse. Just like this video, there are tons of resources on this YouTube channel that you can find. YouTube seems to think that this video is the next best thing that you can watch. I encourage you strongly to watch that. And until next time, landlords, happy leasing.